Is this a courtroom or a comedy show? The judge leaned back in his chair, laughing openly. You expect me to believe you understand constitutional procedure? You can barely structure a sentence. A few people in the gallery chuckled. The black woman standing alone at the defense table didn't flinch. Her hands were steady. Her posture was straight. Her eyes never dropped. I understand more than enough, Your Honor, she said calmly, especially about the difference between law and justice. That made him laugh harder. Difference between law and justice, he repeated mockingly. Did you read that on social media? Silence fell, because she didn't respond with emotion. She responded by placing a sealed envelope on the clerk's desk. And that's when everything in the room began to shift. If you care about real courtroom power reversals, judicial accountability, and the 3 principles of justice in action, make sure you subscribe right now. These stories aren't just drama. They expose how the system actually works. In today's case, it goes far beyond a simple order court hearing. The clerk opened the envelope, whispered something to the judge. The judge's smile disappeared, and for the first time that morning, he stopped laughing. She hadn't come alone. She had come with authority. The hearing had been scheduled as a routine restraining order court hearing. The petitioner Marcus Soule claimed harassment, stalking, and threats. The woman standing alone, Naomi Carter, was the respondent. Marcus sat confidently beside his attorney, a polished litigator who had handled high-profile civil matters and once even published commentary comparing modern jurists to the top 10 worst Supreme Court justices. He had smirked the moment Naomi entered without counsel. Pro se, he whispered loud enough to be heard. Bold strategy. The judge had seemed amused. Miss Carter, the judge began earlier that morning, before the envelope, you understand this is a court of law, not a platform for personal speeches. I understand, Your Honor, she replied. I also understand justiciability, constitutional law. That phrase caught a few legal ears in the gallery. Marcus's lawyer raised an eyebrow. The judge leaned forward. You believe justiciability is relevant to a restraining order? Yes, Naomi answered. Because standing, jurisdiction, and mootness determine whether this hearing should even exist. There was a brief silence. The judge waved his hand dismissively. Let's not pretend this is a constitutional seminar. But Naomi didn't back down. Marcus testified first. He described text messages, claimed she followed him, said she damaged his reputation in professional circles. He painted himself as a victim, deserving immediate protection and potential compensation. 2 victims of crime under civil harassment statutes. He sounded convincing. His lawyer emphasized emotional distress, workplace disruption, reputational harm. Then came Naomi's turn. She didn't approach dramatically. She walked to the podium slowly, Your Honor. She began, before I respond to the allegations, I would like to address standing. Marcus scoffed audibly. The judge rolled his eyes. This isn't law school? It is a court governed by constitutional constraints, she replied evenly. Under justiciability principles, a petitioner must demonstrate actual, ongoing harm, not speculative reputational discomfort. The judge's irritation became visible. Ms. Carter, I will not tolerate lectures. Then perhaps you will. Tolerate documentation. She slid a binder toward the clerk. Inside were certified copies of corporate filings, emails, recorded call transcripts. Marcus's company, Halley Urban Development, had filed a lawsuit against Naomi 3 months earlier. A defamation suit had been dismissed. Why? Failure to state a claim. Because Naomi had exposed internal communications regarding unlawful housing practices potentially violating just past 10 shocking California landlord laws enacted earlier that year. The gallery shifted. Marcus's jaw tightened. You see, Naomi continued, this restraining order petition was filed 2 weeks after that dismissal. Marcus's lawyer stood. Objection? Relevance. It goes to retaliatory motive, Naomi responded before the judge could rule. And whether this court is being used as a weapon, the judge's gavel struck. Sustained? Stick to the alleged harassment? Naomi inhaled. This is about retaliation for whistleblowing. There it was. The word changed the energy in the room. Marcus's attorney attempted damage control. Speculation. But, Naomi continued, I reported housing discrimination to the state regulatory board under the Racial Justice Act, California framework. I filed documentation supported by Craig Kennedy, criminologist, whose research on systemic retaliation was cited. The judge frowned. Ms. Carter, this hearing is not about broader social issues. It becomes about them when a restraining order is weaponized to silence a complainant. Her voice remained steady. No anger, just precision. Marcus leaned forward. You ruined my business, he snapped. Naomi turned toward him slowly. No, she said quietly. Your own emails did. Gasps. The judge slammed the gavel again. This is not a debate. But then the clerk leaned toward him. Whispered. That sealed envelope. The one placed earlier. The judge opened it fully now. His expression shifted. Color. Drained. Because the document inside wasn't from Naomi's side of the table. It bore the seal of a Supreme Court, retired judge, an appointment order. Official Naomi Carter was listed as an appointed legal observer under a judicial conduct review panel authorized to evaluate procedural fairness in select civil hearings. This courtroom had been selected, randomly, or perhaps not so randomly. The judge cleared his throat. Counsel, approach. Whispers filled the room. Marcus looked confused. His attorney looked nervous. The judge returned to his seat more carefully this time. Miss Carter, he said slowly, you failed to disclose this appointment at the beginning of proceedings. You? Did not ask, she replied calmly. The air became heavy. Everything said earlier, the laughter, the mockery now hung in silence. Marcus's attorney tried to regain footing. Your Honor, regardless of any observer status, the facts remain due. They Naomi asked. She walked back to the podium. Let's discuss facts. She projected a timeline onto the courtroom monitor, something self-represented litigants rarely did with such confidence. Dates. Complaint filing, corporate. Investigation, dismissed. Defamation suit. Then the restraining order filing. 2 weeks later. That is temporal proximity consistent with retaliatory litigation, she explained, which courts have warned against in the context of silencing civil rights complaints. Marcus's attorney objected again. The judge hesitated before ruling this time, because now he was being evaluated, and he knew it. Naomi continued. The difference between law and justice is simple, Your Honor. Law is procedure. Justice is purpose. When procedure is manipulated to suppress lawful reporting, the court must intervene. The judge's earlier laughter echoed silently. In his own mind, Marcus shifted in his chair. The confidence was gone. For the first time, His posture suggested vulnerability. Naomi turned one more page in her binder. "There is also audio evidence," she said. Marcus froze. "Audio?" His attorney whispered sharply. "Yes," Naomi replied. "Voicemail messages left by Mr. Hale." She pressed play. Marcus's voice filled the courtroom. "If you don't back off, I'll bury you in court. I'll make sure no judge believes you. You think they'll take your side?" The recording ended. The silence that followed was no longer neutral. It was heavy. The judge leaned back slowly. Marcus's attorney's face went pale. The power dynamic had inverted completely. And this was only the beginning. If you're watching this unfold and you want to see how judicial accountability really plays out, subscribe now. Because what happens next won't just affect this restraining order. It will question the integrity of the entire proceeding. The judge cleared his throat again. "Mr. Hale," he said carefully, "did you leave this message?" Marcus swallowed. "Yes, but no further explanation at this time," the judge interrupted. Because now, the record mattered. Every word mattered. Naomi closed her binder. She didn't look triumphant. She looked prepared, and the judge, who had laughed at her minutes earlier, now realized he was no longer just presiding over a restraining order court hearing. He was presiding under scrutiny, and the person he mocked was documenting everything. The hearing was no longer about whether she ran. It was about why she had to, and who was afraid of the truth catching up. The silence didn't break quickly. It stretched because now every person in that courtroom understood. Something had shifted, and it wasn't small. The judge adjusted his glasses, posture straighter than before. "Mr. Hale," he said carefully, voice measured, "this court takes allegations of retaliatory litigation seriously." Marcus's attorney stood again, attempting recovery. "Your Honor, a single voicemail taken out of context does not establish retaliation. My client was emotional." Naomi didn't move from her position. "Emotional threats, referencing judicial influence," she replied calmly, "are not context. They are intent." The judge didn't laugh this time. He looked at the transcript the clerk had prepared from the audio recording. Then he looked at Naomi. "You mentioned additional documentation?" "Yes, Your Honor." She approached the podium. Again, but this time, slower, deliberate. "I initially filed a housing discrimination complaint under state review. 2 days later, Mr. Hale's company internally labeled me a liability risk. I have the internal memo." Marcus's attorney stiffened. "That document was confidential." Naomi's eyes met his. "It was forwarded to me anonymously, and it is already under regulatory review." Murmurs filled the gallery again. The judge raised his gavel, but gently this time. "Order." Naomi continued. "The memo outlines a strategy to discredit me personally if I did not withdraw my complaint. That strategy includes filing procedural pressure actions." She let that phrase hang. "Procedural pressure actions?" the judge asked. "Lawsuits designed not to win," she answered, "but to exhaust." Marcus shifted again. The confidence he carried into the courtroom had evaporated completely. If you've ever wondered how legal systems can be used strategically, sometimes to protect, sometimes to pressure, subscribe now. Because this case is about more than one hearing. It's about how power behaves when it thinks no one is watching. The judge leaned forward. "Mr. Hale, did you authorize such language in your company's internal memo?" "But that doesn't mean this restraining order isn't legitimate." Naomi didn't interrupt. She waited. Then she turned a page in her binder. Your Honor, may I approach with Exhibit D? The judge nodded. She handed a printed screenshot to the clerk. The clerk handed it to the judge. His eyes narrowed. This appears to be a text message exchange, he said. Yes, Naomi replied. Between Mr. Holey and his legal counsel 3. Marcus's attorney's face drained. The judge read aloud. If the defamation suit failed, we pivot. File something that forces her into court repeatedly. The courtroom inhaled sharply. Marcus looked at his attorney in disbelief. You said that was protected? He whispered. The judge set the document down slowly. Counsel, he said, voice now firm, is this authentic? The attorney struggled. Your Honor, communications between attorney and client are privileged. Privilege does not shield criminal or fraudulent intent. The judge interrupted. That line hit hard. Naomi's appointment as a legal observer now casts a shadow over every procedural misstep that had already occurred. The judge glanced briefly at the seal on the envelope. Beside him, a silent reminder that someone beyond this room would review his handling of this case. And that's when Marcus made a mistake. This is ridiculous, he burst out. She's playing some race card sympathy act. That's all this is. The courtroom froze. Naomi didn't react outwardly, but the words landed heavily. The judge's face hardened. Mr. Holly, he said sharply, you will control your language. Marcus exhaled angrily. She's been attacking my company for months by filing formal complaints through regulatory channels, Naomi replied evenly. Which is lawful. The judge tapped his gavel once. Enough. He turned toward Naomi. You mentioned earlier the Racial Justice Act framework. Yes. Clarify its relevance. Naomi nodded. It establishes protections against discriminatory housing practices. My complaint alleges that Holey Urban Development systematically denied leases to minority applicants through selective documentation standards. Marcus's attorney objected again, weaker this time. Relevance. The judge didn't immediately sustain it, because now he couldn't afford to appear dismissive. Naomi continued. The timing of this restraining order, filed after regulators requested internal leasing records, suggests retaliatory motive. The judge leaned back. He was no longer irritated. He was calculating. The hearing had transformed from routine to consequential. And then Naomi added something no one expected. There is one more matter, Your Honor. The judge looked wary now. What matter? She turned toward the gallery. In accordance with my observer appointment. Okay, this proceeding is being transcribed independently and will be reviewed for procedural neutrality. The courtroom temperature seemed to drop. The judge's fingers tightened slightly around the gavel. He understood what that meant. Earlier laughter, dismissive remarks, potential appearance of bias, all now part of a record. If you're seeing how, quickly authority shifts when accountability enters the room. Subscribe now. Because what happens next doesn't just impact one ruling, it reshapes reputations. Marcus's attorney shifted tactics. Your Honor, regardless of alleged retaliation, my client has expressed fear. The judge nodded slowly. Miss Carter, have you contacted Mr. Holly outside regulatory matters? No. Have you threatened him? No. Have you appeared at his residence or workplace? No. The judge turned to Marcus. Evidence of physical harassment. Marcus hesitated. No. But the messages, Naomi said calmly, were formal notifications of hearings and compliance requests. The judge reviewed the file again. There were no police reports, no prior incidents, only documentation of complaints, and then he noticed something. The initial petition had listed immediate danger, yet the filing date was 2 weeks after the alleged distress began. "Mr. Holly," the judge said slowly, "why did you delay filing if you were in immediate fear?" Marcus faltered. "I was hoping it would resolve." Naomi spoke softly, or hoping regulators would drop the inquiry. The judge didn't reprimand her this time. Instead, he looked at Marcus carefully. Because credibility was unraveling. The power in the room had inverted again. But Naomi wasn't finished. "There's also a financial element," she added. The judge looked up. "The restraining order petition includes a request for attorney fees and lost business revenue." Marcus's attorney interjected, "Standard request." Naomi shook her head slightly. "It cites projected losses tied to canceled housing contracts currently under state review for discrimination." The judge's eyes sharpened. "Are you suggesting this filing seeks preemptive financial leverage?" "Yes." The word was calm, measured, but devastating. The judge closed the file slowly. For the first time since the hearing began, he looked directly at Naomi, not as a nuisance, not as a spectacle, but as an equal participant in legal discourse, and possibly as the most prepared person in the room. Marcus sat frozen. His attorney stared at the table, and the judge understood something critical. This was no longer about protecting a petitioner. This was about whether his courtroom would be used as a strategic tool. The laughter from earlier now felt like a liability. He cleared his throat. "The court will take a brief recess." The gavel struck softer than before as everyone rose. Whispers spread through the gallery. Naomi gathered her binder. Calmly, Marcus avoided eye contact. The judge stepped off the bench with a different expression entirely, because when court resumed, he would have to decide not only on a restraining order, but on the integrity of his own authority. The courtroom felt different when everyone turned quieter, heavier. The judge's expression was no longer casual. No irritation. No trace of earlier amusement. Only calculation. He adjusted the microphone slightly. "This court is prepared to issue findings." Marcus sat rigid. Naomi stood calmly, hands folded in front of her binder. The judge began carefully. "A restraining order is an extraordinary remedy. It is not granted to manage reputational disputes, regulatory discomfort, or business inconvenience." He paused. To obtain such relief, the petitioner must demonstrate credible threat, imminent harm, or pattern of harassment. He looked at Marcus. This record does not support that threshold. Marcus's jaw tightened. The judge continued. "Further, documentation entered into evidence raises concern that this filing may have been motivated, at least in part, by pending regulatory action." Marcus's attorney stood quickly. "Your Honor, sit down, counsel." The words were firm, measured, and final. Naomi did not react, but she did breathe in slowly. The judge turned a page. "This court denies the petition for a restraining order." The gavel struck. A low ripple moved through the gallery. Marcus looked, stunned, but the judge wasn't finished. "And there is more?" Silence returned immediately. Evidence presented suggests potential retaliatory litigation strategy. "This court will forward the record to the State Bar for review of counsel conduct." Marcus's attorney visibly paled. And the judge added, "This court will recommend that regulators examining the underlying housing complaint review today's testimony in full." Marcus leaned toward his attorney urgently. You said this wouldn't escalate. The judge heard him. Mr. Halley, he said evenly, when individuals invoke the authority of the court, they assume risk. Courts are not instruments of intimidation. The words landed like concrete. Then the judge turned to Naomi. Double quotes Ms. Carter. Yes, Your Honor. Earlier you referenced principles of justice. Naomi nodded slightly. The three principles of justice, she said calmly, are fairness, equality, and accountability. The judge held her gaze. Today's ruling reflects this court's commitment to those principles. It was subtle, but deliberate. An acknowledgement. Marcus stood abruptly. So she just walks away after attacking my company? Naomi responded before the judge could. I didn't attack your company. I used the law. The difference between law and justice had never been clearer in that room. The judge struck the gavel again. This hearing is concluded. But the story didn't end there, because as people began to leave, something unexpected happened. A woman in the gallery, older, composed, stood and approached Naomi. She was not just an observer. She was the Supreme Court retired judge who had issued Naomi's appointment. The courtroom staff recognized her. Immediately, even the judge noticed. He stood, a sign of respect. The retired justice nodded politely. Well handled, she said quietly too. Naomi, the judge's expression shifted slightly. He now understood fully what had nearly occurred earlier, and what had been narrowly avoided. Public reprimand, judicial review, reputational damage. Instead, the outcome had corrected itself. Marcus watched this interaction unfold, and for the first time, realization crossed his face. Power wasn't permanent, not when accountability existed. If you believe justice should never depend on who laughs first. Subscribe now. Stories like this reveal how fragile authority becomes when truth enters the room. As Naomi walked toward the exit, Marcus spoke again, but softer now. You could have ruined me? She paused, turned slightly. No, she replied calmly. Your decisions did that. Then she left. Outside the courthouse, reporters were already gathering. Because regulatory cases tied to housing discrimination, especially under frameworks like the Racial Justice Act, California, draw attention. A reporter shouted a question. Ms. Carter, do you believe today's decision will impact the broader investigation? Naomi answered carefully. Today wasn't about winning, it was about process. And process protects everyone. Behind her, Marcus exited through a side door. Head lowered, no cameras followed him. In the weeks that followed, regulators expanded their review of Holly urban development. Internal emails, surface. Leasing patterns were analyzed. Minority applicants, who had been quietly rejected, were contacted. In compensation, the victims of crime statutes were evaluated for potential restitution pathways if discrimination was substantiated. The state bar opened an inquiry. Not dramatic headlines, not explosive arrests, but structured accountability, the kind that lasts longer than spectacle. And the judge, he issued a public memorandum weeks later, emphasizing courtroom neutrality and the ethical duty to avoid even the appearance of bias. A quiet correction, but a meaningful one, because sometimes justice isn't loud. It doesn't always come with handcuffs. Sometimes it comes with a denied motion and a record that can't be erased. Naomi returned to her work, reviewing cases, observing hearings. ensuring that justiciability, constitutional law standards were applied properly. Marcus returned. 2 depositions and regulatory interviews. Very different rooms, very different posture, and the laughter that started it all. It became a footnote in a transcript, one that reminded everyone present that authority without accountability is temporary, but preparation shifts outcomes. If this story showed you how strategy, composure, and knowledge can dismantle intimidation, stay with this channel, because here, justice isn't simplified, it's examined.